The burden of proof in North Carolina relative to DWI charges is exactly the same as it would be for an armed robbery or drug trafficking or even shoplifting. The burden of proof under the pattern jury instructions in North Carolina, I'm going to paraphrase them, is proof that fully satisfies or entirely convinces the jury or the finder of fact that the accused is guilty beyond a reasonable doubt. It's not all doubt or vain or fanciful doubt or any amount of doubt. It has to be a reasonable doubt based on the totality of circumstances and using everyday common sense and life experiences. The state has the burden of proof. They have the burden of production, meaning that they have to present sufficient evidence first for the matter to even get to the finder of fact, to make it over that initial hurdle. We will oftentimes refer to that as a prima facie showing. And then they also have the burden of proof to show that you're guilty as charged. The defendant carries no burden of proof in North Carolina to show that you're innocent. You're not required to present evidence. You have no burden of production. You're not required to take the stand. And if you do not present evidence, if you do not testify, if you do not explain yourself, there's actually an instruction that the judge gives to the jury that says you can't hold that against that person. You are truly innocent until and unless you are proven guilty. It is the highest standard in the land. There are different legal standards. We have this online where we use it as a series of hurdles or steps where you've got no evidence, some evidence, reasonable suspicion, probable cause, greater weight of the evidence, which is a preponderance of the evidence, which is the civil court standard, clear, cogent, convincing evidence, which is what you deal with in juvenile cases, DSS cases, if you're going to take away someone's parental rights. And then you've got reasonable doubt, and then you've got beyond a reasonable doubt. It's the highest standard of proof in the land. It does not matter if you're charged with driving while impaired and it's related to a murder case, or just regular old driving while impaired, or reckless driving, or even speeding for that matter in a criminal charge. There are differences between criminal and infraction matters in speeding tickets, but the state has the burden. If you have questions about this, I really encourage you to talk to a lawyer right away. You should not assume that you're automatically guilty, nor should you assume that charges get dismissed just because you're a good person or have no prior record. These cases are complicated, they're time-consuming, and because of the possible consequences, they merit serious consideration of the facts, law, and science behind DWI charges in North Carolina. My name is Bill Powers. My telephone number is 704-342-4357. Hope to hear from you.